The scope of the agent's duty. In the previous section, we examined agent disclosure responsibilities and the risks associated with agents completing seller disclosure forms. We also discussed how agents must disclose material facts known to them while avoiding stepping outside their professional role. That discussion naturally leads to the next critical issue in disclosure law, defining the scope of a real estate agent's duty in a transaction. There has been considerable discussion within the real estate industry about whether a real estate licensee must verify all representations made by the seller or independently discover every possible defect in a property. Some of these arguments arise from misunderstandings about the services that a real estate agent actually provides. Real estate agents perform a wide range of services for their clients. These services include marketing properties, locating suitable homes for buyers, preparing purchase contracts, negotiating transaction terms, coordinating inspections, and guiding clients through the escrow process. Agents also provide resources to help clients obtain financing, title services, inspections, and relocation assistance. Despite the wide range of services provided, most real estate professionals are compensated only when a transaction successfully closes. In many transactions, agents invest significant time and resources in marketing, showings, negotiations, and transaction management without receiving compensation unless the property sells and escrow closes. This contingency-based compensation structure is one of the defining characteristics of the real estate profession. If the home does not sell, the buyer does not purchase a property, or the transaction fails to close escrow, the agent typically does not receive payment for the services rendered or the expenses advanced during the process. Because agents provide specialized transaction services, Arizona law requires real estate licensees to possess expertise in the general purpose and legal effect of real estate practices, principles, and transaction documents. Under ARS, paragraph 32-2124E2, licensees must demonstrate knowledge of agency agreements, purchase contracts, deeds, mortgages, security agreements, bills of sale, and other real estate transaction instruments. However, the law does not require a real estate agent to possess the technical expertise of other licensed professionals. An agent is not expected to function as a home inspector, structural engineer, plumber, electrician, surveyor, appraiser, or environmental specialist. Recognizing this distinction is essential to understanding the true scope of the agent's duty. Services provided by a real estate agent. To better understand the scope of an agent's responsibilities, it is helpful to consider the range of services agents typically provide during a transaction. Agents often assist sellers by marketing the property through advertising, open houses, professional photography, digital marketing campaigns, and listing the property in the Multiple Listing Service, MLS. These activities are designed to attract qualified buyers and generate competitive offers. For buyers, agents often identify properties that meet the buyer's needs, schedule showings, and physically tour multiple homes with the buyer until a suitable property is found. Agents then assist with preparing and submitting purchase offers, negotiating terms with the seller, and managing the exchange of counteroffers. Agents also help coordinate inspections, walkthroughs, lender communication, title coordination, and escrow timelines. Throughout the transaction, they keep their clients informed about the status of the transaction and guide them toward professional resources when specialized expertise is required. These services require knowledge of contracts, negotiation strategies, disclosure obligations, and transaction management, but they do not transform the agent into a technical construction expert. Why an agent is not a property inspector. Some critics have suggested that real estate agents should be responsible for discovering all defects in a property before the transaction closes. While this idea may appear to enhance consumer protection, courts and legislators have recognized that imposing such a duty would create significant problems for the real estate industry. One well-known case illustrating the potential consequences of expanding broker liability is Easton v. Strasburger, a California case that imposed a broad duty on listing brokers to conduct inspections of property in order to discover defects. The decision led to a surge in litigation and significantly increased the cost of errors and omissions, E&O, insurance for real estate professionals. Insurance carriers began withdrawing coverage from the California market, and the cost of professional liability insurance increased dramatically. In response to these unintended consequences, the California legislature adopted California Civil Code, paragraph 2079-12, to clarify and limit the scope of broker inspection duties. The lesson from these developments is that an agent's duty must be clearly defined and appropriately limited in order to protect both consumers and the real estate industry. Arizona courts have generally recognized that agents should not be held responsible for discovering technical defects that require specialized training or professional equipment to identify. Practical guidelines for defining the agent's duty. Although real estate agents are not required to perform technical inspections, there are still important disclosure responsibilities that arise during the transaction process. If an agent has actual knowledge of a material defect, the agent must disclose that information to the client or the buyer. This obligation arises from common law fiduciary duties and has been reinforced by Arizona court decisions. For example, the Arizona Supreme Court in Jennings v. Lee, 105 Arizona 167, 1969, recognized the duty of a broker to disclose material information relevant to the transaction. Similarly, Coldwell Banker v. Camelback Office Park, 156 Arizona 214, Appar 1987, reinforced the obligation of brokers to communicate material facts affecting a client's decision-making process. If an agent notices a suspicious condition during a property showing, the agent should bring the condition to the client's attention and recommend that the client obtain an appropriate professional inspection. For example, visible ceiling stains may indicate a roof leak, and cracks in walls or foundations may suggest structural movement. Courts have suggested that if agents are ever required to identify defects, the duty should be limited to conditions that would be reasonably observable by a prudent real estate professional during a typical viewing of the property. This principle was discussed in Hopkins v. Fox and Lazo Realtors, 625 A2D 1110, NJ 1993. In practice, this means agents should recognize obvious warning signs and recommend further investigation when necessary. Responding to client questions. Another important aspect of the agent's duty arises when a client asks specific questions about the property. When a client asks about an issue such as plumbing connections, structural integrity, sewer service, or electrical systems, the agent should avoid providing definitive answers unless the agent personally knows the information to be accurate. A safer and more professional response is often, "I do not know, but we can find the answer." Courts have recognized that when professionals voluntarily answer a client's inquiry, they may assume responsibility for the accuracy of that information. In Lopata v. Miller, 712 A2D24, Mid-App in 1998, the court explained that a professional who responds to a client's question must exercise reasonable care in providing that information. The proper role of the agent is to guide the client toward qualified professionals, such as inspectors, engineers, or contractors, who can provide reliable answers. Passing along information. From third parties, agents often transmit information provided by sellers, inspectors, contractors, lenders, or other parties involved in the transaction. When doing so, the agent should clearly identify the source of the information and explain whether the information has been independently verified. Courts in other jurisdictions have addressed this issue. In Asilzada v. California, Federal Bank 2000, the court explained that a buyer's agent may transmit information provided by the seller without independently verifying it, as long as the buyer understands that the agent is simply relaying the information. Similarly, in Aranki v. RKP Investments, Inc., 194 Arizona 206, Appar 1999, the Arizona Court of Appeals held that a listing broker was not liable for passing along seller information absent evidence that the broker knew or should have known that the information was false. This case illustrates an important principle in Arizona real estate law. Agents must disclose material information they know, but they are not automatically responsible for independently verifying every representation made by other parties. Why expanding agent liability would harm consumers? Some advocates have argued that agents should be strictly liable for any undiscovered defect or inaccurate statement in a transaction. While this idea may appear to increase consumer protection, legal scholars have warned that such a rule would actually create negative consequences. Real estate professionals are trained in transaction management, contract law, and negotiation, not structural engineering or construction analysis. Expecting agents to diagnose every potential property defect would create unrealistic expectations and dramatically increase litigation. As one legal commentator observed, a condition that appears to be a harmless cosmetic issue to a real estate agent might be recognized as a serious structural problem by a licensed contractor or engineer. For this reason, defect discovery should remain the responsibility of professional inspectors and technical specialists. When agents disclose known information, recommend inspections, and encourage buyers to investigate potential concerns, they are fulfilling their professional role without stepping outside their expertise. Online discussion. Why is it important to clearly define the scope of a real estate agent's duty in a transaction? Answer: clearly defining the agent's duty ensures that agents focus on their professional responsibilities, such as disclosure, negotiation, and transaction management, without being expected to perform technical inspections that require specialized training. Why are real estate agents not expected to function as home inspectors or engineers? Answer: real estate agents are trained in contracts, negotiations, and real estate law, not construction or engineering. Technical evaluations of property conditions should be performed by licensed inspectors and specialists. What should an agent do if a client asks a technical question about the condition of the property? Answer: the agent should avoid guessing and instead recommend that the client obtain the answer from a qualified professional such as a home inspector, contractor, or engineer.